Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. You ever have one of those days where just nothing goes right? Well, yesterday was a day like that, and now today is another day like that. So this may be a little bit choppy, but I have to explain what happened first. Yesterday I made a video about American Airlines and the problem that they had with their lawyers putting up a defense that was certainly an appropriate legal defense, one that could be asserted, but it was clearly inappropriate in the context of how they did it. We're going to talk about that a little bit more here in a little bit in a vague way. But there are some things that YouTube just doesn't like, and this treaded into one of those areas, so I'm going to be a little bit vague about it. But it amazes me how I plan to get something done, and then this morning, when I'm getting ready to do this video, the lawnmowers are out there and they're making noise. So this may be a little choppy. I may have to chop it up a little bit. So let's discuss this particular American Airlines case. Now, we don't need to get into what actually happened, but here's the situation. You have a negligence claim against the airline, and it's probably negligent hiring if I had to guess, or negligent supervision, one of the two. And it involved a flight attendant who was the person who committed the acts that were sued over. So the plaintiff files a negligence lawsuit, and one of the defenses in a negligence lawsuit is always going to be comparative negligence or comparative fault. In the answer, the lawyers asserted this comparative fault doctrine, and it created a huge public relations issue for the airline. But comparative fault is indeed a defense that can and should be used in the right circumstance. So American Airlines lawyers filed an answer that asserted this comparative fault. And in that answer, they asserted that the plaintiff was at fault for what happened, except that the plaintiff in this case, the person who was affected by it, was a 9-year-old girl. And again, we don't need to get into that, but it's not ever appropriate to assert comparative fault against a child. And the reason it's not appropriate is because children do not have the judgment and discretion to always be able to identify things that are hazards to them. And as a result, if you say, well, anybody walking down the street would have seen that hole, a 9-year-old child might not see that hole. If you're gonna make the claim of comparative fault, you have to have facts to back that up. And without getting into the details, let's just say that they didn't have the proper details to back that up. And this kind of goes back to what I have said numerous times on the channel about there being one magic way in which they defend all negligence cases. And I think it bears itself out in this particular case. It wasn't our dog. It didn't bite you. If it did bite you, you deserved it because you annoyed the dog. And what are you complaining about anyway, since you aren't even hurt? Well, these are the principal tenets of what I call the delay, deny, and defend approach to defending lawsuits. That's how you defend every case. You delay, you deny, and you defend. And by defend, what I mean is you go out and you take depositions, you make the other guy spend money to keep up with you, you travel different places, if at all possible, you get experts in Africa. That's kind of a hyperbole, just in case anybody's wondering. Sometimes people have trouble with my hyperbole, but at any rate, that is sort of the way these are defended. That's especially true when it deals with a situation where an insurer is paying for the defense. As you know, insurance provides not only a fund of money if you happen to get sued for someone's injury on your property, but it also provides lawyers, and those lawyers get to defend your lawsuit, and they sometimes get to defend your lawsuit by saying and doing things that most normal people just wouldn't do. But hey, sometimes there are good lawyers, and sometimes there are really bad lawyers. A good friend of mine who lives in our community here and who sold insurance for about the last 30 years explained that when there are large losses, like there were in Hurricane Katrina, the insurers generally take the approach that they deny all the claims initially. And they will sort of churn the file, they'll reconsider, they'll look at more evidence. It may take you a year to get a final denial from your insurance company. And they may offer to pay a pittance, as they often did in Katrina. But most of the time, it's delay, deny, and defend. They'll delay the litigation by filing multiple motions for continuance. They'll hire lawyers on the cheap. In other words, they're not paying them their regular $350, $450 an hour to defend this case. They're hiring lawyers that they know will use associates who they'll wind up paying $100, $110 an hour. Now, without going into the details, I'm going to tell you that the lawyers that were hired in this case made a claim of comparative fault against a 9-year-old girl, and the circumstances were such that they should not have done this. And no reasonable person would think that that would be an appropriate defense. And you're probably wondering, okay, if you've got all these lawyers who apparently went to college, and then they went to law school, and then they started practicing, and they have experience, how in the world could something like that make its way into a filing? Well, I'm going to tell you. So the bottom line is, insurers do not always hire the best lawyers. So here's what happened. The case came in. They had to get an answer on file. Probably because their motion to dismiss was denied. They had to get this answer on file, and so a senior partner hands it off to an associate and says, get an answer on file. And the associate, because he wants to do the job, but he doesn't want to offend the boss, goes in and says, but boss, how do we defend this case with these ridiculous facts that go against us? There's really not much of a defense we can offer. And the senior partner says, comparative fault. Just blame the kid. Blame the kid for whatever happened. I don't care what happened, just blame the kid. That'll take care of it. That'll at least get us on file and, maybe we'll be able to cut the losses a little bit. And that's how dumb things get done in big law firms. The associate drafts the pleadings, the senior partner doesn't read them, has them filed, and then when the plaintiff gets that and shares it with the family, they're absolutely appalled at reading that defense. In light of multiple news reports and backlash of victim blaming, American Airlines walked back that defense. The public statement that they issued, which was them falling on their sword, saying mea culpa, I am not worthy, it seemed to distance itself from the defense team, and there's a good reason for that, because they fired the defense team after this. They said, our legal counsel, our outside legal counsel retained with our insurance company, made an error in this filing. Well, geez, do you think? American Airlines said, the included defense is not representative of our airline, and we have directed it to be amended this morning. We do not believe this child is at fault. Our core mission is to care for people, and the foundation of that is the safety and security of our customers and team.
You serious?
And I think it is absolutely appalling that you would use this kind of a defense in a case involving a 9-year-old girl. The airline's lawyers got fired, so maybe it did have a happy ending. And of course, the reason they got fired is because feces, like rainwater, flows downhill. American blames the insurer blames the law firm gets fired, the partner says, I don't even know who put that in there. And the associate who did no more than do what he was told is probably now in the free cheese line, wondering how he went from $110,000 every year to unemployment compensation. But I don't want to mask something that is important here, and that is there is a real and useful legal principle at work, and it can and should be used in appropriate cases to defend them. But you have to use it judiciously, no pun intended. Comparative fault, also known as comparative negligence, is a legal doctrine used in tort law to allocate damages when multiple parties are at fault for causing harm. The concept is particularly relevant in civil litigation involving negligence. Here is a detailed explanation. Comparative fault is the principle that allows for the apportionment of damages based on the degree of fault or the degree of negligence attributed to each party involved in causing an injury or damage. Now, the main goal of comparative fault is to distribute the financial responsibility for damages in proportion to each party's level of fault. This aims to ensure that a fairer allocation of damages compared to the traditional all-or-nothing rule of what was called contributory negligence. Now, there are different types of comparative fault systems. There are two primary ones. The first is pure comparative fault. In pure comparative fault, a plaintiff can recover damages even if they're 99% at fault. However, their recovery will be reduced by their percentage of fault. So here's an example. If a plaintiff is awarded $100,000 in damages, but is found by the jury to be 70% at fault, they can still recover $30,000. Then there's modified comparative fault. In a modified comparative fault system, there are two main variations. The 50% bar rule. This is the rule in Kansas. A plaintiff can recover damages only if their fault is less than 50%. If they're found to be 50% or more at fault, they cannot recover any damages. And then there's the 51% bar rule. A plaintiff can recover damages only if their fault is 50% or less. If they're found to be 51% or more at fault, they can't recover any damages. So, in a 51% bar rule situation, if a plaintiff is awarded $100,000 in damages and found to be 40% at fault, they can recover $60,000. But if they're found to be 51% at fault, they'd get nothing. Now, the application in civil litigation is pretty simple. In a negligence case, the court or jury evaluates the evidence to determine the percentage of fault for each party involved. This process involves examining the evidence and the actions or omissions of each party and how those contributed to the injury or damage. Once fault is assigned, the total damages are calculated, and then they are reduced according to each party's percentage of fault. This calculation determines the final amount each party is going to get or pay in the case. Now, comparative fault in most jurisdictions replaced contributory negligence. As I mentioned, comparative fault allocates damages proportionally. Contributory negligence, on the other hand, in jurisdictions that follow that rule, if the plaintiff is found to even be slightly at fault, they may be completely barred from recovering any damages. It was a very harsh rule, and this is the reason why we now have comparative fault in most of the states, because it was such a harsh rule. Now, it has some impacts for litigation strategy. Most notably, you don't use it on a 9-year-old child. But for plaintiffs, it helps you understand what your risks are. If you look at this and you say, well, my client was speeding and he didn't wear his seatbelt, the jury is going to assess a percentage of fault. You sit down with the plaintiff ahead of time and you say, look, I'm going to go and on closing argument, I'm going to say, look, you need to charge my client with 20% fault so we can appear reasonable against these insurance companies who are going to want you to bear all of the fault. And of course, defendants can use the comparative fault to mitigate their liability by proving that the plaintiff shared significant responsibility for their injuries. One way this comes up a lot is in medical negligence cases, where, for example, John Doe is starting to have chest pain and he's feeling really, really bad. He tells his wife, oh, I'll be fine, don't worry about me, nothing to worry about me about. And then all of a sudden he falls over and they call the ambulance comes and they defibrillate him, they take him to the hospital, and during the cardiac cath treatment, the cardiac catheterization where they're trying to assess how much damage his heart has sustained, the catheter goes through an artery and the man winds up dying on the table. Well, the defendants have an opportunity to showcase his own negligence by saying, look, if he had come to us at the beginning when he first suffered some chest pain, we probably could have done this much easier and under much less stress, and he would probably not have suffered any injury at all. So you have to apportion some fault to him for the delay. That's one way that a comparative fault works in a medical negligence case. And it also works in car accident cases. Basically, comparative fault is a fair and balanced approach to resolve negligence claims by ensuring that each party with some degree of fault is assigned their degree of fault by the finder of fact. And then if the finder of fact doesn't apply or do the math, then the court does the math and adjusts the damage in that way. So that's what I have for you today. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. And then, if you would, do something kind for somebody. Just go out of your way, maybe open a door, let somebody go in front of you in line. They've got one jug of milk and you've got a cart full of groceries. Let them go ahead. It'll delay you a minute at most. So those are the kinds of things that I'm talking about when I'm talking about doing a kindness. Just something small but significant. It'll be significant to the person that you do it for. After you do that, come on back tomorrow, join me down here at the beach, and catch me, and we'll do something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.